Imagine a tenant sitting in their living room, enduring severe, continuous vibrations and noise from an industrial factory right next door. Next door, on the same day, a pipe suddenly ruptures at that factory, sending a catastrophic flood of dark water across the residential garden. Meanwhile, a cloud of noxious fumes escapes the factory, drifting over the wider village, causing a severe respiratory injury to a guest visiting the house. If you look at these facts and immediately begin a standard negligence analysis, you will fail the exam. The law treats land as a unique, immovable asset, and it requires a highly specific set of tools to resolve conflicts between neighbors. This is a classic tort law problem question, presenting a single interconnected factual matrix that must be dismantled piece by piece. The baseline for our analysis is private nuisance, which requires reclaimant to prove an unlawful interference with their use or enjoyment of land. To solve this problem question, we must dissect the facts across 4 strict doctrinal dimensions: private nuisance, public nuisance, the rule in Rylands v. Fletcher, and negligence. Mastering the strict boundaries between these 4 torts is the defining difference between a passing grade and a failing one. We begin with continuous noise. In private nuisance, interference must be substantial and unreasonable. Courts balance specific factors. Unlawful means the principle of a reasonable user, not criminal behavior. We weigh the defendant's land use against the neighbor's quiet enjoyment. The first major factor is the character of the neighborhood, known as locality. The standard of reasonable comfort adjusts to the environment. In Sturgis v. Bridgman, the court established that what constitutes a nuisance in the refined residential area of Belgrave Square would not necessarily be a nuisance in the industrial district of Bermondsey. We must also account for abnormal sensitivity. Suppose the tenant in our scenario claims the vibrations are ruining their highly delicate, specialized home recording equipment. Applying the rule from Robinson v. Kilvert, the claim is judged against the standard of a normal user of the land. If ordinary use is unaffected, the defendant is not liable for the claimant's hypersensitivity. Examiners frequently see students confuse unreasonable conduct with unreasonable interference. A factory owner can take every possible precaution, act with perfect reasonable care, and still be liable in nuisance. Private nuisance liability hinges entirely on the objective external impact on the neighboring land, completely independent of the factory owner's internal standard of care. Now we must determine who actually has the legal right to sue for these vibrations, the tenant holding the lease or their visiting guest. The House of Lords settled this in Hunter v. Canary Wharf. To have standing in private nuisance, a claimant must have a right to exclusive possession, a strict proprietary interest in the land. Applying this rule, the tenant, who holds a proprietary interest through their lease, can sue. The guest cannot. This strict property requirement creates friction with Article 8 of the European Convention on Human Rights, which guarantees respect for private and family life, including the home, regardless of ownership status. In Dobson v. Thames Water Utilities, the Court of Appeal addressed this tension. They ruled that an award of damages to the property owner is usually sufficient just satisfaction for the entire household's Article 8 rights. Therefore, on a final exam, a proprietary interest remains the absolute required gatekeeper for a private nuisance claim. We move to the sudden pipe burst. Private nuisance fails immediately here. Nuisance requires a continuing state of affairs. This flood is an isolated event. Instead, we apply Rylands v. Fletcher. The claimant must prove the defendant brought something likely to do mischief onto the land, it escaped, and was a non-natural use. The critical hurdle is non-natural use. Under Transco, the use must pose an exceptionally high risk. Applying Transco to our facts, standard water piping is considered an ordinary, natural use of land. The Rylands claim fails entirely on this element. Furthermore, the case of Cambridge Water Co. added a remoteness constraint, requiring that the specific type of damage caused by the escape must be reasonably foreseeable. Do not treat Rylands v. Fletcher as a general strict liability catch-all in your exam answers. The courts have deliberately narrowed this tort, rendering it almost completely ineffective for ordinary industrial accidents. This leaves the final set of facts: the noxious fumes drifting over the village and the guest's severe respiratory injury. Private nuisance is useless to the guest. They lack the required proprietary interest, and crucially, private nuisance does not compensate for personal injury. We resolve this through public nuisance. This is defined as an unreasonable act that materially affects the reasonable comfort and convenience of a class of the public. While it is primarily a crime enforced by public officials, an individual can bring a civil claim if they prove they suffered particular harm over and above that suffered by the public at large. Because the guest suffered a specific, actionable personal injury, while the rest of the village merely endured the smell, public nuisance operates as the vital catch-all where standard land torts deny relief. A top-tier exam answer does not analyze these torts in isolation. It explicitly contrasts nuisance directly with negligence. This comparison table outlines the doctrinal limits. First, if the harm is intangible, continuous, and the claimant has a proprietary interest, plead private nuisance. Conversely, for a single, isolated incident causing personal injury or property damage, negligence is appropriate. Looking at the bottom of the table, this structural distinction also dictates your remedies. Negligence only remedies past harm with damages. Private nuisance allows a court to grant an injunction, legally forcing the defendant to stop their behavior in the future. Though under Coventry v. Lawrence, the Supreme Court modified the traditional Shelfer criteria, giving courts flexibility to award damages in lieu of an injunction if planning permissions or the public interest weigh heavily enough. Finally, be alert for concurrent liability. If a continuous nuisance causes actual, tangible physical damage to the land itself, the facts support pleading both private nuisance and negligence. Exam success does not come from reciting definitions. It comes from proving to the examiner exactly why one legal tool is structurally superior to another for the specific facts on the page.